Hello, everybody. I think almost everybody is in. Thank you for waiting. You should be seeing on your screen the UC Hastings Annual Supreme Court Review and Preview. I'm Rory Little. I'm the moderator for the program. This is an annual thing that we do with the Academic Dean's Office. So thank you to the Academic Dean's Office, and particularly Irma Hernandez, who set up all the tech. And we have some great panelists and some great conversation. We're going to try to zip through as much as we can in the first hour, because I know some of you may have to go to a class around 4:30. I've got a few slides to share, and then we'll probably stop sharing the slides. These are slides that you can get from the Academic Dean's Office later if you want them for any reason. I'm going to give very, very brief introductions. Jodi Short is the Assistant Dean for Research, and she is also the Honorable Roger J. Traynor Professor of Law at Hastings. She has a PhD and master's degree from UC Berkeley and a law degree from Georgetown Law in Washington, D.C. Thank you, Professor Short, Dean Short. Professor Radhika Rao has a law degree from Harvard, and most relevantly, she clerked for Justices Harry Blackmun and Thurgood Marshall at the U.S. Supreme Court. Professor Matt Coles is a Hastings Law grad, I'm very proud to say. He was, prior to joining Hastings, the Deputy National Legal Director of the ACLU, and more relevantly, perhaps, the Director of the ACLU's LGBT project. And he was one of the attorneys on a Supreme Court decision called Evans versus Romer, which of course is a very important equal protection case that may get mentioned later today. I am the Joseph W. Kachet Professor of Law at UC Hastings. I took my law degree from Yale, and I also clerked at the US Supreme Court for Justices Brennan, Stevens, and Justice Stewart all in 1 year, and feel free to call me sometime and I'll tell you more about that story. So here's a brief overview of the term, what's called the October 2019 term, which is the term that just ended this past June. First, it was really unprecedented in many ways. 2 months of oral arguments were canceled due to the coronavirus shutdown. And then they held arguments in May. They haven't held arguments in the month of May in many years. And they took 10 cases and deferred them, 10 or 12 actually, into the current term, which begins this coming Monday on October 5th. They held their oral arguments by phone, which they have not done before. Of course, they're still not using any video. It's hard enough for them to use phone, and Zoom would be beyond them, I think. The justices were questioned or got to ask their questions in order, which is usually not true. It's usually a free-for-all. And suddenly, Justice Thomas, who had asked maybe 2 questions in 15 years, started asking questions just like all the other justices, good, solid questions. Because of seniority, he was going first or second, and it just became a different justice than the one we're used to, at least in arguments. They live streamed the audio. They're going to do that again starting on Monday, live stream oral arguments. That's never been done before. And you can hear oral arguments, all of the Supreme Court's oral arguments, by going to their website and checking for the oral argument audio. This is past arguments as well as the live stream one starting next week. Last term, maybe because of the pandemic, but also because their workload has been shrinking over the years, they only did 61 cases. 53 of those were signed opinions, so it's a very small number of opinions, one of the smallest numbers in many years. I do criminal law particularly, so I'd like to say how many were criminal law, about a third of the docket. I've got some patterns that I detect here. We can talk about that as we go forward. These are my opinions, not the opinions of anybody else necessarily on the panel or at Hastings. Here's a picture of the court with their headphones on. That's actually not an official picture. That was made by a Hastings student for me last May. Did a great job. The coming term, okay? By tradition, it begins on the first Monday in October. That's this coming Monday. As we know, Justice Ginsburg has passed away, and there's a new justice who is nominated. Whether she will be confirmed remains to be seen. And when she'll be confirmed remains to be seen. She will certainly not be sitting on the arguments starting on Monday. So it'll be an 8-justice court starting on Monday. Here's a few facts about the coming term. There are 31 cases already granted for review. I actually think it's more than that. That may be a stat that's a little bit out of date. The arguments have been scheduled through December. They normally will hold arguments for 4 months in the spring. So there are a lot of empty spots. There will be more grants announced, I think, this coming Monday. The justices met yesterday, I don't think in person, I think by phone, for what's called their long conference or their summer recess conference, where they handle all the cert petitions that have come in during the summer. That's usually as many as 1,000 cert petitions. So we'll probably see, I would say, at least a dozen grants on Monday. They are going to be holding, starting next week, 4 arguments a day. That hasn't been done for about 2 or 3 decades. When I was clerking there back in the 80s, they used to do 4 a day. But more recently, they've only done 2 a day. But they're catching up for the cases that were postponed from last term. The arguments will be remote, by phone, no video, live stream feeds. By tradition, a case that is argued to 8 justices, this is not a rule, they don't have to follow this, but if the cases are argued next week to 8 justices and there were to be a tie vote, normally they would hold it over and re-argue it. They don't just say, come on and listen to the arguments that were held, listen to the recording before you became a member of the court. If they can decide a case with 8 justices with a majority, say 5-3 or something like that, they will decide it. Otherwise, I think they may re-argue some of those cases. This is just a list of top decisions from last term. Some of these you're going to hear about today, and some of them you're not. And this is only 10 out of the 61. And again, you don't have to read this in detail. You can get these slides later if you want them. And here's some cases that are granted for review in the coming term. Again, some of these you'll hear about today, and some of these you won't. And again, you can get this slide later if you want it. The SCOTUS blog website is probably the best source of information about the court for you students who haven't familiarized yourself already with SCOTUS blog. That's where you should go, and you fish around on that website and you can find all sorts of information. And with that, I'm going to stop sharing my screen, I hope. And we are going to begin sort of presentations. Each of us have divided up the cases. We're going to hopefully be commenting on what each other say. We will take questions. I hope we're going to use the hand raising function in the chat, in the participants field. So if you want to ask a question, raise your hand. The chat, I think, is working, and you can put a question there. Otherwise, I'd love it if you would just please not be using the chat, just to chat. Those of you who are watching on YouTube, I don't know that we're going to be able to take any questions from YouTube. It'll kind of depend how many questions we've gotten through the hand-raising function of Zoom. But the Zoom site has capacity for 300 people. So if you're dying to ask a question, sign into the Zoom link if you can find it. And with that, I'm going to turn it over to Professor Rao.
Thank you, Rory, for that wonderful introduction. And thanks to so many of you for being here. It's wonderful to look out and see your faces and your names. So I am going to speak about last term's case of June Medical Services against Russo, the big abortion decision, and this upcoming term's Affordable Care Act case, California against Texas, Texas v. California. So first, on June Medical Services v. Russo, this case was really long, 138 pages. It was composed of six separate opinions. In fact, all 6 of the men justices sitting on the Supreme Court found it necessary to write an opinion in this abortion case, while the 3 women, all 3 female justices, remained silent. Kind of interesting. Justice Breyer authored the plurality opinion for the joined by the 3 women justices, Justices Ginsburg, Sotomayor, and Kagan. And then the fifth vote was provided in a surprising about face by Chief Justice Roberts. He provided the fifth vote to strike down the Louisiana law regulating abortion providers, even though he voted to uphold an almost identical Texas law just 4 years ago in Whole Women's Health against Hellerstedt in 2016. But despite appearances, this was not a big win for abortion rights. Chief Justice Roberts wrote a really narrow opinion, concurring in the judgment based upon the doctrine of stare decisis, which you all know, adherence to precedent. And essentially, here's what Roberts said: I join the dissent in Whole Woman's Health, and I continue to believe that case was wrongly decided. The question today, however, is not whether Whole Woman's Health was right or wrong, but whether we adhere to it. So that's the fifth vote for finding the law unconstitutional. Now, what exactly was at issue? Justice Breyer, who authored the majority opinion in Whole Woman's Health, also authored the plurality opinion in this case, and he said that the case involves the constitutionality of a Louisiana law that is almost, quote, word for word identical to the Texas law that was at issue in the earlier case. The Louisiana law required doctors who perform abortions to have admitting privileges at local hospitals within 30 miles of the place where the abortion was performed. And the state justified the law as protecting women's health by essentially making sure that the doctors were credentialed, that this admitting privileges requirement could serve a credentialing function and ensure that safety was being served. But the district court in this case made really detailed factual findings that first, abortion was extremely safe already in Louisiana, and there were no health-related problems that the new law was designed to cure. That despite good faith efforts, the doctors had been unable to comply with the admitting privileges requirement. They couldn't get admitting privileges at local hospitals for reasons that were entirely unrelated to their competence. That enforcing the law would result in a drastic reduction in the number and the geographic distribution of abortion providers, and that as a result, many women seeking safe and legal abortions in Louisiana would be unable to obtain them. In fact, the law was projected to reduce the number of clinics in the state from, I think it was going to be 3 before the law was enjoined, to 1 clinic, and the number of physicians providing abortions in Louisiana, the entire state of Louisiana, from 5 physicians to 1, perhaps 2 providers. And the 1 doctor would be providing abortions at a single clinic in New Orleans. So that was going to be the impact of this law. The current test for measuring the constitutionality of these kinds of abortion regulations is, of course, the undue burden test of Planned Parenthood against Casey, which provides that laws that have the purpose or effect of imposing a substantial obstacle in the path of a woman seeking an abortion prior to fetal viability are unconstitutional. In the earlier Texas case from 4 years ago, Whole Woman's Health against Hellerstedt, the court interpreted Casey to require consideration of the burdens a law imposes together with its benefits. Like, that needs to look at both of those things. So Justice Breyer, writing in this new case, Russo, says, he reiterates that constitutional standard that had been applied in Whole Women's Health. And he says that the court has to consider the burdens the law imposes on abortion access together with its benefits. If a law doesn't really provide any health benefits, and it imposes a number of burdens, even if they're not huge, it's unconstitutional. Justice Breyer concluded that the Court of Appeals in this case, it was the Fifth Circuit, should not have reversed the district court's findings of fact. It should not have reversed its ruling unless the district court's findings of fact were clearly erroneous. And in this case, the court found that the district court had ample evidentiary support for its holdings, for its findings. And so they justified the district court's holding that the Louisiana law, like the Texas law upon which it was modeled, was also unconstitutional. Chief Justice Roberts, however, disagrees with Breyer's statement that the court should be weighing burdens against benefits. He thinks that creates a balancing test that requires the weighing of imponderables, and the court should stay away from it. But he agreed ultimately with the court's conclusion, based upon the principle that like cases should be treated alike. According to Roberts, the Louisiana law imposes a burden on access to abortion just as severe as that imposed by the Texas law for the same reasons. Therefore, it cannot stand under our precedents. Justice Thomas wrote an angry dissent in which he says that the court created an amorphous right to abortion based on a right to privacy, which is grounded in the legal fiction of due process. And he poked fun at Justice Douglas's penumbras and emanations theory of privacy. But what I want to say about whole woman's health is that perhaps the most momentous aspect of this case isn't what it said on the merits, but some of the procedural arguments it raised, whether abortion providers and clinics have standing to assert the rights of their patients. This doctrine of third-party standing was the subject of a lot of the dissents. Specifically, Alito argued that there's actually a conflict of interest between physicians who provide abortions and the women, their patients. And he argued that the idea that a regulated party could invoke the rights of a third party for the purpose of attacking legislation enacted to protect the third party is, quote, stunning. So that is a really frightening development in this case, because a lot of prior contraception and abortion cases have been based upon this doctrine of third-party standing. The court majority found third-party standing on the part of the physicians and medical providers challenging the law on behalf of women. Some of the prior cases were Griswold against Connecticut, Eisenstadt, Gonzalez v. Carhart. So revisiting the third-party standing doctrine could have a tremendous impact, not just on reproductive rights litigation, but a whole slew of other kinds of litigation. And standing, of course, is the subject of the Affordable Care Act case as well. But before I turn to that, many of you might be wondering about how abortion rights are going to be affected by the loss of RBG. And so I just briefly wanted to say that I think the truth of the matter is that Roe versus Wade is already long gone. And Casey was always an empty vessel, malleable enough to mean whatever a majority of justices said that it meant. So even when RBG was on the court, there were only 4 votes, really. Chief Justice Roberts wasn't really providing a 5th vote to uphold abortion rights. So perhaps the situation isn't all that different today. Okay, that brings me to the next case that I'm going to briefly preview, California against Texas. And I think I've got maybe 1 or 2 minutes left. So a couple of minutes. Oral argument in the Affordable Care Act case is set for November 10th, a week after the election. And these cases basically challenge the minimum coverage provision, known as the individual mandate, which requires people to maintain a minimum level of health coverage. And that, of course, was upheld as constitutional under Congress's taxing authority in the Sebelius case. But since that time, Congress cut the tax penalty to 0, calling into question the constitutional basis for the individual mandate. So basically in 2018, a group of like 20 Republican states led by Texas filed suit to have the Affordable Care Act struck down as unconstitutional. And 2 individual plaintiffs later joined the suit, arguing that the individual mandate compelled them to purchase health insurance coverage, even though there was no penalty if they failed to comply. Another group of states, 17 led by California, were permitted to intervene and to defend the Affordable Care Act. And so this case raises 3 issues. Number 1, do the individual and state plaintiffs have standing to challenge the individual mandate of the Affordable Care Act if the individuals face no penalty for noncompliance, and if the states aren't really impacted, is there standing? Number 2, does reducing the tax penalty to 0 for failure to satisfy the individual mandate make the provision unconstitutional? Because it removes the constitutional basis upon which Chief Justice Roberts predicated his opinion joining the other 4 justices in upholding the Affordable Care Act as constitutional. And lastly, if the individual mandate is struck down as unconstitutional, is it severable from the rest of the Affordable Care Act, or does the whole thing fall in its entirety? What's going to happen? You might be wondering. Well, a couple of possibilities. The Supreme Court could be deadlocked 4-4 if we don't confirm a new justice, in which case the lower court judgment would stand. And the Fifth Circuit sent the case back. Although it found that the individual plaintiffs have standing, and it found that the individual mandate is unconstitutional without the tax penalty, the Court of Appeals remanded the case to the lower court for them to figure out whether the mandate was severable or not. So in that case, it would go back to the lower courts. But if you get a 9th justice, the Supreme Court could decide that there's no standing here, in which case nothing really happens. Or the court could decide that there is standing and that the individual mandate is unconstitutional without a tax penalty, in which case not that much would change if they say that, because it's already an unenforceable individual mandate because there's no penalty. The big deal would be, does this mean if the individual mandate, if they hold that unconstitutional, does the whole law fall, or just that provision? Is it severable? And of course, the most far-reaching consequences would occur if the court ultimately decides that all or most of the ACA must be overturned, because that would mean the loss of health insurance for some 23 million Americans in the middle of a pandemic.
Thank you. Thank you, Professor Rao. Can I ask you, what is your view on the severance question? I have read people saying that, gee, this is not a hard question, that we would never strike down such a large statute for the loss of such a small portion. And I have read others saying, oh, this is a very serious question. I don't know much about the doctrine of severance.
Yeah, great question. I've actually been reading a little bit about this too. And I think one of the really interesting things is that the very justices who are most likely to rule that the provision is unconstitutional are also the justices who have been arguing for taking a narrow approach on questions of if one constitutional provision is if part of a law is unconstitutional, don't strike the whole thing. Don't apply a facial challenge, just consider the part that's unconstitutional to be unconstitutional, and the remaining parts should stand. So in a way, if they remain true, those conservative justices, to their position on this issue in other contexts, then they should take a narrow approach, and the rest of the Affordable Care Act should remain. On the other hand, maybe this will just give them an opportunity to reveal their hypocrisy and to apply different standards.
Do our other panelists have questions about either Russo or California versus Texas? Go ahead, Matt.
I just have a comment on the severability question, because I think what makes it a little different here is in Justice Roberts, in his opinion in the case of holding the individual mandate, placed enormous emphasis on the notion that the mandate was essential to the law, that the rest of the law would fall apart, that Congress's design was based on that. And I think the case, in a certain sense, is designed to put him in an uncomfortable position where he would have to take that back. But I think what puts me in the camp that says this is a silly question really is the Congress that repealed the individual mandate, of course, could have repealed the entire law. Or it could have changed the severability provision. It didn't do that. It just took one little piece out of it. And to say that somehow it took that one little piece out of it and didn't notice it was pulling the whole thing down with it, kind of silly.
Professor Short, anything to add?
No, I'm good. I share their views.
Let me ask one more question, Professor Rao. Stare decisis in Russo. Was there a discussion by the Chief Justice who provided the fifth vote about stare decisis? Because there's a lot of stare decisis chatter in other cases from last term, because everyone sees Roe versus Wade coming down the pike. And whether to follow it or not is really viewed as a matter of stare decisis more than anything else.
Yeah, wow, that's a really hard question. So, in a way, how broadly or narrowly are they going to interpret stare decisis? I feel like, and this is kind of what I was heading towards at the end of the talk. I feel like Roe versus Wade is already gone. We keep talking about Roe versus Wade, but Roe was transformed by Planned Parenthood against Casey. Planned Parenthood against Casey claimed that it retained the essential holding of Roe, but that really meant so little. They got rid of the trimester framework, and all they kept was the viability line. And Planned Parenthood against Casey says only laws whose purpose or effect is to impose a substantial obstacle are unconstitutional. Chief Justice Roberts, when he writes about Casey in his opinion in Russo, he says he takes the court at its word. He says only substantial obstacles are unconstitutional. And he says that I think what he would do is say, even if we stick with stare decisis and adherence to precedent, only laws that effectively bar abortion in a huge number of cases are going to be held to be unconstitutional. And basically, pretty much everything else is not going to be viewed as a substantial obstacle. So even with precedent, the precedent that we're going to have isn't a very protective precedent, because Casey itself is so malleable that it can be transformed and read pretty much any way you want. So in a way, what I think would be actually better, more transparent and more candid, would be for the court to overrule it, because then we'd know where we are. Whereas here we have the appearance of protection, but the reality of Casey doesn't actually afford much protection at all.
We'll have to continue this discussion at another place. Although I think it's a little glass half full or half empty. I'd rather have some precedent that says there is some constitutional right to choose than to have them both overruled and say, oh, let's just see how it plays out politically. But let's go to Professor Coles, who has another set of cases to talk about. Thank you.
Okay, thanks, Rory. I'm talking about, from last term, 3 consolidated cases, Bostock, Harris, and Zarda. These 3 cases pose this question. Does the ban on sex discrimination in employment in the 1964 Civil Rights Act apply to discrimination based on sexual orientation or gender identity? And as the case finally arrived at the Supreme Court, it's a battle of competing conservative judicial philosophies. Essentially, the plaintiff is taking a textualist approach and saying, of course it bans discrimination based on sexual orientation or gender identity. Suppose you have 2 employees, each of whom has a male partner. One of the employees is a woman, she gets to keep her job. One of the employees is a man, he loses his job because his partner is male. The court says, obviously, or the argument goes, obviously, sex played a motivating factor, a role in the decision to terminate. And similarly with gender identity. One day you have an employee who identifies and presents as a woman. Sometime later, after a transition, he identifies and presents as a man. You have terminated him, if you have for that transition, because he was a woman and now he's a man. And obviously, sex played a role in the decision to terminate. The textualist position, this is just simple what the words mean. On the other side, originalists, or as they've increasingly become, people who advocate the original public understanding of what a law meant, not really what the words mean. And they look at it and say, Congress in 1964 did not mean to protect lesbians, gay men, bisexuals, and transgender people from discrimination. They only meant to protect traditional women and traditional men. The court decides 6-3 that the textualists have it, not the originalists, over a very strong dissent from Justice Alito, and Justice Gorsuch's opinion for the 6-member majority is just pure textualism. There's not a word in the opinion about why it would be a good thing to have employment discrimination laws, or even, for example, why employment discrimination laws as civil rights laws ought to be read broadly or liberally. It's just pure textualism. But for those who have been working on the issue over the years, textualism was a lot better than anything else. And two fascinating aspects of the case. One, in the 70s, 80s, and 90s, all of these arguments about gender identity and sexual orientation and the literal words were presented to federal district courts and federal courts of appeals. And those courts universally turned those challenges back and said, that's obviously not what Congress had in mind. And to me, what's really fascinating here is that what to the courts was obviously wrong on both gender identity and sexual orientation for 30 years after the passage of the law is now obviously right to the Seventh Circuit en banc, the Second Circuit en banc, and 6 out of the 9 justices in the Supreme Court. And you want to ask yourself, what made that obvious transition? I'll tell you from my point of view, what made that transition of one thing being obvious to its complete opposite being obvious has much less to do with the development of the law and everything to do with the LGBT rights movement and the way in which that transformed the public understanding of who LGBT people are from the notion that being gay was simply bad behavior like gambling or drinking, and that it represented a difference in kind, people behaving badly, not like good people, to the notion that gay people and trans people are really just like everybody else. With gay people, it's just that a part of their identity is attraction to forming intimate relationships with people of the same sex. And when you change that understanding, it becomes obvious and not so much clear that this isn't what Congress would and wanted to do, that this isn't what the words mean. One other interesting thing, toward the end of his opinion, Justice Gorsuch says, in response to the notion that this is going to put a horrible imposition on employers with religious views, he says, well, maybe not. Maybe there'll be religious exceptions. Which brings me to 2 other cases that got decided at the end of the term quickly. One of them called Our Lady of Guadalupe. It's a parochial school case in which the court decides that the ministerial exception, and the notion of a ministerial exception being the government can't tell a church how to hire and fire its ministers. And the court in a case a few years ago named Hosanna Tabor said the ministerial exception can apply to teachers. And in Guadalupe, I think it effectively says, if the church says that any parochial school teacher is a minister, then they're a minister. So the so-called ministerial expression has been broadened to potentially take the civil rights laws and other kinds of government regulation out of a lot of church hiring. And I think that may go even farther in the next couple of years. The other case with a little interesting note, and I'll tie this together in a second, is the Little Sisters of the Poor case. This is a case in which the Trump administration expanded the exception to the contraceptive mandate in the Affordable Care Act, the part of the Affordable Care Act that said employers had to provide access to all of the FDA approved methods of contraception. The Trump administration passed a new exception to that, which said, if you have a religious objection, you don't have to provide access to all of them, or perhaps even to any of them. The court upholds that in an administrative procedure decision, but Justice Alito writes an opinion in which he says, not only was the Trump administration allowed to do that, it was required to do that by the Religious Freedom Restoration Act. And he also says, basically, look, if a church tells us that supporting or opposing an activity is part of its faith, we have to take their word for it. All right, that brings us to this term. This term, there's a case in front of the court called Fulton against the City of Philadelphia. Fulton against the City of Philadelphia poses the question, can the City of Philadelphia insist that if Catholic Charities wants to get a contract and participate in the foster care system, that it consider married same-sex couples as potential foster parents? Most people, myself included, think the court took this case to reconsider a case called Employment Division against Smith. This is a 1993 case written by Justice Antonin Scalia that says essentially, look, if the state has a law that's neutral toward religion in its terms and generally applies across the board, there is no free exercise claim to make. There's just no free exercise objection to it. There's a couple of ways the court could reconsider or modify Smith. It could pull the free exercise clause really up to the standards of most other constitutional rights. With most constitutional rights, we say, look, if you discriminate on the face of the law, or on the face of the law, you apply, for example, the freedom of expression, that raises a First Amendment or a 14th Amendment issue. But we also say, if a law has a disparate impact against a particular group, or if it impacts speech, even though it doesn't say that in so many terms, we'll ask whether it was intended to have that impact and give it serious constitutional review if it does. Smith seemed to foreclose that, and I think at the very least the court ought to say that those same constitutional principles apply to free exercise of religion. But I suspect what Justice Alito would like to do is to say the free exercise clause is just like the Religious Freedom Restoration Act. And if the state does anything that has any significant impact on religion at all, even if it's not a disparate impact, even if it wasn't intended, then that ought to call up very, very skeptical, strict review, ought to insist that the state have a compelling interest and that it be narrowly tailored to achieve the interest. And I think his opinion in Little Sisters was in one sense looking forward to this. It's puzzling that the court would pick this case to do this because it's such a terrible case to present the issue. I mean, this isn't the silly city of Philadelphia acting as a regulator. It's not talking about how the church can operate. It's not talking about the church's membership policies. It's not even, it's not regulating the church. It's saying we're letting out contracts for people to help us perform the government function of foster care. Here are the policies we want to have. And the church is effectively saying, we should be able to get the contract even if we don't like one of your policies because of religious beliefs. If you start thinking about the variety of religious beliefs we have in the United States, that's a pretty astonishing proposition to say we can contract with the government, we could throw out whatever terms we don't like on a religious basis. I strongly suspect the court's not going to say that. I suspect that the court will take this case, do what it wants to do with Smith, and send it back for the lower court to determine the church's role. But who knows? My fear here is that Justice Alito is going to bring the free exercise clause and try to make it the strongest constitutional right, at least the strongest constitutional right of the moment. Let me say one other thing. That reflects on the vacancy on the court now. When I graduated from Hastings back when dinosaurs roamed the earth and Sir Ernest Clinton Hastings was still on the California Supreme Court, and began to work on LGBT rights, court was not a good place to be. And most of the things we as lawyers wanted to do weren't in court. They had to do with passing local ordinances. They had to do with state laws. They had to do with regulations. But court was generally a pretty bad place to be. And the federal courts were an incredibly hostile place to be. I said at a symposium at Hastings in 1979 that I considered it professional malpractice to bring a gay rights case in federal court. And I did at the time. What we did was we used our lawyering skills outside of court, and we tried to use the courts defensively as much as we possibly could, to use the courts to keep a political movement in the fray and to be putting out by its opponents. And I suggest to you, people who want to think about lawyering for change have to think about the defensive use of the federal courts, keeping things away from the US Supreme Court, working through state constitutions, and relying on the First Amendment as much as possible to make change. I've been an avid opponent of tinkering with the court's jurisdiction or tinkering with the size of the court. But I feel after the Republican Party put down as a marker, the rule is no appointments during an election year, and 4 years later decide, well, that was just really about whether we had the power to do it, and we did then, and you don't now, so we're going to do it. I think all bets are off. If they want to take the court to 15, fine. If they want to use the exceptions and regulations clause to take away its power to declare something unconstitutional except by a 3/4 vote, that's okay with me. That's all okay with me because I believe if you want to make change as a lawyer, you need to think defensively.
I have no possible way to react to that other than to say, what a great performance. Radhika, Jodi, any comments on what Professor Coles has said?
I just finished teaching a con law class, Matt, where what you just ended with was kind of what we were talking about. And we had just finished talking about Brown versus Board of Education, Washington against Davis, and affirmative action, or starting that, and the depressing holdings of the Supreme Court and constitutional doctrine. And I think the lesson is that the court hasn't been our friend for a really long time, and maybe we should just acknowledge that and move, to other venues. So I do think that that is a very positive message, or can be taken as a positive message. Don't go to the court, but don't give up. Right? Go to other branches of government and use your law degrees to, in wonderful and important ways. And so don't despair in this moment.
Absolutely. I couldn't agree more. There's this little sliver of time between the very late 50s to the mid 70s when the court truly is invigorating constitutional rights and using them but most of the rest of the time, it's been more an obstacle to individual rights than a backer of it. And we just need to get used to that. We're all kids in the 60s.
I would just jump in and say, don't be afraid of politics. I think something that I hear often, and maybe one of the reasons that students go to law school is because, they want to resolve things in court. We want the court to save us. We sort of look at that parchment paper of the Constitution and think like that's going to save us. But we really need to not be afraid of getting into the political trenches to defend our beliefs about what the Constitution means.
And we do, Professor Short, we do want to get to you. The only other thing that's interesting to me, Matt, is if Amy Coney Barrett is put on the court, Alito may get himself a partner for the effort to, really invigorate, if you will, the religious clauses. And I think you're going to see some schisms within the block of justices we call conservative on those questions. I'm not sure that Kavanaugh and Roberts are going to want to go along with that vision of the world. And that itself is interesting in how the progress of the Supreme Court goes. You cannot know 5 years from now where some of these justices may be on whatever the pressing questions are of that day, as opposed to the day today. So again, don't give up, even if you're a lawyer. Keep fighting.
Absolutely.
Okay. Professor Short.
Okay, thank you. So I am going to talk about some of the structural con law cases that the court decided last term and that it's poised to decide this term. Usually there's much less action on the structural front. I mean, by definition, right? These are the foundations of our constitutional order. And one might imagine that those are relatively stable. And that was true for a long period of time, but this court over the last many years has shown a voracious appetite for rethinking foundational jurisprudential understandings that have structured our government for almost a century. And nowhere is this more true than in the jurisprudence surrounding the administrative state. Last term, the court signaled that it wishes to rethink the terms on which Congress can delegate authority to administrative agencies. This term, the court returned to questions of Congress's power to structure the offices it creates in administrative agencies, and in so doing, articulated what is perhaps the most robust endorsement of unitary executive theory ever to appear in a majority opinion. So I'm talking about the Seila Law case versus Consumer Financial Protection Bureau, in which the court found unconstitutional the good cause removal provision protecting the director of that agency, the Consumer Financial Protection Bureau, from being fired at the whim of the president. Why? Because 1 is less than 5. I'm not being facetious. Literally, the decision rests on a formalism that is that facile. The court did not overturn Humphrey's executor in that case. You may recall that Humphrey's executor endorsed an identical good cause removal restriction on federal trade commissioners. Rather, what the court said in Seila Law was that Humphrey's executor created a narrow exception, carved out from the general rule established in Myers that applies only to multi-member agencies and not to single director-headed agencies. So the general rule, the court says, is that the president must have the unfettered ability to remove officials implementing the law in the executive branch. Now, you may recall that the Constitution says not a single word about the president's removal power. The court finds this very strong version of this general rule in the Take Care Clause and the Article 2 vesting clause, pursuant to how interpretations of these clauses have been developed by unitary executive theorists. And the court quotes some anodyne language from Madison on the separation of powers to argue basically that the founders intended to give the president unfettered removal authority, even though they declined to mention this in the Constitution. The court characterizes cases that have gone against this newly minted general rule as narrow exceptions that must be strictly confined to their facts. So, although the CFPB director is subject to the exact same statutory removal restriction as the FTC commissioners upheld in Humphreys, that restriction is unconstitutional because there's only one of her and there were 5 of them. Justices Gorsuch and Thomas would have gone even further. In a concurring opinion, they espoused the view that no good cause removal restrictions are permissible, no matter how many leaders of an agency there are. Now, at least their position has the virtue of coherence, but it would have the effect of rendering much of our government unconstitutional. So this all may seem a little abstract. Why should you care? Look around you. Look at what is happening because of the politicization of administrative agencies. Interference by political actors in decisions that statutes assign to experts and to scientists. The political manipulation of public health guidance at the CDC, the political manipulation of scientific protocols and the vaccine approval process at the FDA are just the most blatant examples of this. The court would have you believe that this is all going exactly how the founders intended. Because this manipulation is so blatant, they would say, now we, the electorate, can hold the president accountable for it. We know where to point the finger. We know where the buck stops. The problem is, much of this manipulation is calculated precisely to obscure the president's failures and bolster his chances at re-election. It is the utmost in dangerous folly to call this accountability. And that's precisely what the court is doing in this case. And none of this is constitutionally inevitable. This foundational principle of presidential supremacy to which the court genuflects is nowhere found in the Constitution. For a group of justices who disdain privacy rights for exactly the same reason, they're weaving a thin cloth to cover their policy preferences. Particularly when the Constitution explicitly gives Congress the power to create executive branch offices and to condition those offices in ways that advance the goals of the statutes enacted jointly by Congress and the president. So this term, the court will continue its romp through the foundations of the administrative state. And the question is, will the court continue picking off good cause removal restrictions as it goes, or will it use an upcoming case as an opportunity to place some boundaries on this hunting expedition? So the upcoming case this term is called Collins versus Mnuchin. It's a challenge to the structure of the Federal Housing Finance Agency. The Federal Housing Finance Agency, like the Consumer Financial Protection Bureau, is headed by a single director who is protected by a for-cause removal restriction. The FHFA was created in the wake of the 2008 financial crisis as an independent agency to oversee the Federal National Mortgage Association, or Fannie Mae, and the Federal Home Loan Mortgage Corporation, or Freddie Mac. Fannie and Freddie are government-sponsored entities that also have private shareholders. They're kind of these hybrid entities, but they are ultimately government entities. Their purpose is to provide stability in the secondary market for mortgages and to promote access to credit. And they were both implicated as major contributors to the collapse of the mortgage market in the 2008 financial crisis. The FHFA was created to oversee their activities and to try and make sure that doesn't happen again. So, what is to become of the director of the Federal Housing Finance Authority? Is it a slam dunk after Saylor law that their removal protection is gone? Well, maybe, but maybe not. The appeal is from a Fifth Circuit case that found the removal restriction unconstitutional. So the Supreme Court is going to be reversing an opinion that removed the removal protections on this officer. The Saylor law opinion actually mentions the Federal Housing Finance Authority's director and notes that the cases might be distinguishable because the FHFA regulates other government entities rather than private conduct, as the Consumer Financial Protection Bureau does. Could this become the basis for a new exception to the general rule of unfettered presidential removal power? One can only hope. The court has, in other cases, noted the importance of independence for financial regulators. And so the question is, will they draw a line here, or will they continue to tear down duly enacted statutory protections agreed to by both Congress and the president and sensible for good governance? We shall see. Now, to be clear, it's not all conflict and controversy. So I'm going to end on a case that was actually unanimously decided. And that case is Chiafalo versus Washington State. This is known as the faithless electors case. So by now, you all know that under the Constitution, the president is not selected by popular vote, but rather by the votes of electors selected by each state. Most states have statutes requiring electors to cast their electoral votes for the candidate that won the popular vote in that state. Washington has such a statute, and Washington's statute also provides that electors who cast faithless votes or who vote for a candidate that did not win the state's popular vote can be penalized for up to $1,000. In 2016, the majority of citizens in Washington voted for Hillary Clinton, and a slate of electors was appointed to cast their votes for her. Chiafalo and two other electors did not do so. They were part of a scheme to try to deprive Donald Trump of a majority in the Electoral College by convincing other electors, particularly those from states Trump had carried, to cast their vote for someone other than Trump. And so Chiafalo and his compatriots voted for Colin Powell instead of Hillary Clinton, hoping that others would follow their lead, which of course they did not. And then Washington State fined them for casting their vote faithlessly. A unanimous court upheld Washington's ability to do so. The electors argued that the Constitution contemplates that electors will exercise discretion in casting their votes, that they will use their wisdom and judgment to select the best candidate regardless of what their state tells them to do. Washington argued that the Constitution, in Article 2, Section 1, gives states the authority to appoint electors in such manner as the legislature thereof may direct. It is entirely within the legislature's power to require electors to support a candidate, and it is entirely within the legislature's power to back up that requirement with a penalty. And as I mentioned earlier, a unanimous Supreme Court agreed with the state of Washington that those authorities to regulate the votes of electors belong with the state. Now, to pivot, I guess, to our general discussion, what does this mean for all the wargaming of electoral college scenarios that we've been hearing about lately? And I mean, I would love to hear other panelists' views on this. My intuition is probably nothing. I think that there was so much agreement about this case, and the scenarios that are being played out are so extraordinary that I'm not sure that Chiafalo gives us a whole lot of guidance. I guess I would just ask us to remember two things. It is important to remember, as we're cycling through, all of this all of these things that are being thrown at us, it's important to remember that all states have legislation on the books specifying how electors are appointed. And so if a rogue legislature wished to appoint electors by a different method, this existing legislation would have to be repealed in duly enacted legislation passed by the legislature, signed by the government, by the governor, and new legislation would have to be enacted, providing the new way that electors are going to be appointed. This seems highly unlikely to happen. And so I guess this makes me less worried about some of those scenarios that people are gaming out than others might be. And if I can be permitted to end on a note of optimism, I do think it's important to point out that this was a unanimous decision. And my most fervent hope is that whatever comes before the court, if the court is deciding a case about something so political as the Electoral College, it will strive to do so on the basis of this kind of broad consensus.
Great. Thank you, Professor Short. You know, I don't have anything to say in this particular election, although it is an eye-opener, I think, for our students and others to learn that states could change how electors are selected in ways that we haven't really considered before, and that there could be sort of crazy variations among states. There are 2 states that don't do the winner-take-all thing, right? They go by counties.
Nebraska and Maine.
That's
so, so you know, the consensus isn't 100%, but I do think you're right that at this point, it's hard to imagine any state getting its legislative engine working that quickly. And I also think maybe the debate performance last night, I'll go out on a limb, suggested to many people that Trump isn't necessarily the standard bearer they want to have, even if they like certain politics. Matt, go ahead. Just
a quick observation, if Jodi, where things could maybe still run off the rails. I think in states that have a legislature in the hand of one party and the governor in the hand of another party, legislators who don't like what the popular vote total is may well say that under the elections clause of the Constitution, the power to decide how to pick electors is solely up to them. They don't have to pass a law. They just have to pick electors. And that question, unfortunately, is, I think, undecided and sits between 2 lines of authority. Justice Ginsburg, a couple of years ago, said, you know, when state legislatures were picking senators, the governor had no role to play. The legislature just picked the United States senator. But when state legislatures do redistricting, that's legislation, and you need the governor to chime in. And just as the Pennsylvania House of Representatives today passed a resolution setting up a special committee on the 2020 election and empowering it to subpoena, do hearings. And I think it's a potential prelude to the Pennsylvania legislature, which is closed by Republicans, not liking very much the way the election goes. But we'll see. I hope that's wrong.
So Matt, if I can jump in on that, I mean, you're right. There's an ambiguity in Article 2, Section 1. It does ultimately say that the states appoint, right? So there's the language that says the states appoint the electors, but it's by the methods that the legislature shall direct, right? And so I mean, I take your point. I think it's more difficult for legislatures to enact. It would be easier for a legislature to simply assert its preference if there were no statutory law in the background. I think it's more difficult. I mean, once legislation about how electors are appointed is on the books, then I think a legislature acting alone would be hard pressed to say, well, we're just going to come in and do it a different way, right? I mean, I may be wrong. I think you're right. No, it's an open question, but
I agree that ought to be right.
Okay, we're a little bit already close to over our time, and we haven't had any questions. I'm going to do my little thing very quickly. And the first thing I'll say, to end on the note that Professor Short noted on, I focus on criminal cases in this particular annual symposium. There were 2 other cases which were unanimous or close to unanimous last term, both having the word Trump as the plaintiff. Trump versus Vance and Trump versus Mazars. And the court unanimously rebuffed the president's arguments that there is some absolute privilege of the president, of the executive, to be able to assert when a third party is subpoenaed for documents relating to the president. And they did this in powerful terms. And of course, Chief Justice Roberts held the opinion, which he has the power to do. There were some details on the enforcement of these subpoenas. They were both remanded to the state authorities in the Vance case, the DA of Manhattan, who had issued a subpoena in a criminal case, to third parties for records of the president's, and to, in the Mazars case, a congressional subpoena. They were both remanded for sort of whether they could be enforced and how should they be enforced, and those details remain still to be seen. And there were some disagreements among a couple of justices on those details, but for the most part, they were unanimous in rejecting the powerful executive branch claim of privilege. So there is a line beyond which some justices will not go. And I, for one, am an advocate of life tenure because I think it gives them the independence to depart from their ideological friends and brethren when they're confronted with an argument they think is extreme. I'm not going into detail on those cases. I'm going to share my screen for a second. There was a case called Ramos versus Louisiana. This was 6-3. Justice Gorsuch again sided with the so-called liberals on the court and ruled that the right to jury trial, which applies to all states through the doctrine of incorporation, includes the requirement that a jury be unanimous. Right to jury is in the Bill of Rights. Unanimity is not. But the court has held in the past that federally, that right to jury trial requires unanimity for conviction. Louisiana did not have a unanimous jury requirement, and neither did Oregon. Mr. Ramos was convicted of a relatively unsavory set of offenses, but he was only convicted 10-2. And the question is, would that be constitutional? The court said 6-3, no, unanimity is a constitutional requirement of the right to jury trial. In order to do that, they had to get past an obscure case called Apodaca. And ultimately, they said they would overrule Apodaca. There was some disagreement as to whether Apodaca even counts as a full precedent. So there is a lot of discussion in this case about stare decisis. And I think many people think the discussion of stare decisis in this case was because they were using it as a testing ground or a stalking horse for arguments about stare decisis that they have been having internally and will have when Roe versus Wade and Casey come up to the court for the suggestion that they be overruled. Interestingly, Justice Kavanaugh set his own theory of stare decisis out here. He said, I am not happy with the doctrine up to now. That's a relatively bold move for someone who is pretty new on the court. This was his first full term. The other thing that Justice Kavanaugh did in this case, interestingly, and this is the second or third time he's done it, he went out of his way to write about the racist origins of the non-unanimous jury verdict rules. And it was undoubtedly clear in Louisiana that idea that a jury could be non-unanimous in criminal cases was a product of the Jim Crow era after the Civil War, when suddenly formerly enslaved people could vote. And suddenly they said, oh, maybe conviction shouldn't have to be unanimous. There's legislative history that is so expressive, it's just horrible, that they don't expect more than one or two Black people ever to get on a jury to begin with. But if they do, they shouldn't be able to hold up a conviction. So Justice Gorsuch writes about that. By the way, Justice Alito writes in his dissent, oh, I don't think that's relevant, which really shows you where Justice Alito is on certain scales. But Justice Kavanaugh, in his separate opinion about stare decisis, initially says, let me tell you about the racist history in Louisiana and other places. And he goes on at some greater length than the majority opinion. There's no reason for him to do that other than, I think, and this is my theory and only my theory, I believe Justice Kavanaugh actually believes that race is a serious third rail and his time in Washington, D.C., all of his years growing up, everything, have made him more attuned to issues of race and racial equality than perhaps some of the other justices, such as Justice Alito, who says this isn't even relevant. So Ramos is interesting, not just for its criminal procedure holding, but for its discussion on these other topics. The other case I'll tell you about is a case called McGirt. I just have to tell you about this case. It's funny, quote unquote, it's entertaining, quote unquote, but it's also incredibly serious for Native American rights in this country. So here's a case where the question ends up being, does the state of Oklahoma have criminal jurisdiction over its territory as a state, or is 43% of the state actually Indian territory because of some treaties dating back to 1832, such that the state does not have criminal jurisdiction, and if anyone's going to prosecute, it has to be either the federal government or the tribes. No one took this case seriously when it was first coming up. And then the 10th Circuit, which is where Justice Gorsuch came from, actually ruled that the defendant had a good claim here. Again, the defendant was convicted of an unsavory thing and is seeking to vacate his conviction. And Justice Gorsuch, like the Bostock case, actually takes the plain language, he says, of these treaties, which said, and I'm quoting here from the slide, it promised a permanent home to the whole Creek Nation so long as they shall exist. The court ruled that this had never been abrogated. This treaty had never been abrogated by Congress. And so it's still in force today. Justice Gorsuch says this is plain language. And he says, the fact that this will cause sort of practical concerns in some sense doesn't matter. And in some sense, we think it can be resolved, and there are lots of people who filed amicus briefs that say that it will be. But he also says it doesn't matter. It doesn't matter because not just the plain language, but the force of the claim, the promise, is powerful. So here, Justice Gorsuch, again, is linked with the four liberals to reach a decision that was contrary to the other members of the court. And the last slide I'll show you, there are a bunch of cases granted for the next term. I won't go into detail. The first one is going to be, is Ramos retroactive? Do all the jury convictions that were non-unanimous get to be reconsidered? There aren't that many, and it won't be that hard to reconsider them. So the court actually dealt with that claim, I think, in the Ramos decision itself. The other one that I think is interesting, maybe to students, Van Buren versus United States. Is it a crime for someone who is authorized to access a computer to access the information for an improper purpose? In other words, if you're allowed to use your spouse's, your significant other's laptop, but your significant other says, don't look at my email or don't look at my photo files, and you do, have you committed a federal crime because you have authorized access, but you were accessing it for an unauthorized purpose? This is a question that has split the circuits, and there's a wide range of applications ranging from very serious business questions where you would think this would be a very bad thing for someone to do, to the highly sort of personal and somewhat trivial instances of people who share computers and share laptops. So that'll be a big case. I think that's the end of my slide deck. So I'm going to stop sharing, and I'm going to say that it's time for questions, unless my panelists have something in reaction to what I said or others have said that you'd like to talk about. We're at about an hour and 10 minutes. And it is being recorded. Those of you who are with us, this is being recorded so people can access it later. I think it will be distributed by Hastings. I will take questions in the chat or in the participant thing if you can raise your hand. If you're not able to raise your hand, but you're able to write a chat, feel free. And if those two functions aren't working for you, but you'd like to ask a question, I have no problem if you want to unmute your microphone and just say something. I'm going to give it all right. Mauricio Grande. The one thing I would ask is that you activate your camera. Thank you, Mauricio. And tell us you're a Hastings student.
I'm a Hastings student. I'm a 3L.
Okay.
And I wanted to ask about more the preview, I guess, part of this. But in terms of the Ford Motor Company versus Montana case, dealing with specific personal jurisdiction and be arising out of or related to prong of that test for personal jurisdiction. I'm wondering if Ruth Bader or Justice Ginsburg's death will affect the outcome, or if it's going to lead us more in the dark with regard to specific jurisdiction, or if it's going to offer a little bit more clarity. The court will offer more clarity about that now.
I'm happy to defer this to my colleagues. I don't think you have any civil procedure professors here.
Well,
Yeah, Matt.
I'm only Civ Pro 1. You know, I think the big way in which Justice Ginsburg's absence is going to make a difference is they love to give her civil procedure opinions to write, and I think if she'd still been around, she probably would have written it. You know, I thought she often took a fairly restrictive view of jurisdiction, broader in some of the specific personal jurisdiction cases, but very narrow in the general personal jurisdiction case. So I think it's really hard to figure out how her and I have no idea of what perspective Justice Barrett thinks about how jurisdiction works. So no idea. And I don't have much of an inkling of how that case is going to go.
I don't know much about it either. Mauricio, what do you think?
Well, I would like some clarity, but I think just given the jurisprudence on personal jurisdiction in the last couple of years, it might not be as clear as possible. But I mean, the reason why I ask is because she always took a very like fair and reasonable, or really focused on the reasonableness and fairness aspect of personal jurisdiction. And seeing that she is gone now, and the current composition of the court doesn't really seem like there will be much emphasis on that. I mean, besides Justice Sotomayor, but I was wondering if Amy Barrett might have offered any sort of like leaning one way or another, probably not the reasonableness and fairness part, but I just was curious about that.
I just don't have any further insight into it. I do see another question, Mauricio, if we can go. Jasper Ford Monroe, who I happen to know is, I think, a third year. Jasper, if you're on line here, why don't you, if you can, activate your camera and ask your question. I can read it out loud if you're not in a place to do that. No camera. Okay, Jasper says, I'd like to know more about the theory used to challenge the individual mandate, I guess in the California versus Texas case. Having been upheld when it had bite, how can it be struck down without one? Professor Rao, I'll turn it over to you. I think a lot of us may have an answer on that.
Yeah, well, I think the argument is that if the constitutional basis for upholding the individual mandate was that it imposed a tax under Congress's taxing theory, and if now there is no tax penalty, then isn't it by definition, like hasn't it been undermined? The constitutional basis is taken away, so isn't it unconstitutional? So I think, Jasper, you're suggesting how could it be upheld if it has no constitutional basis? But I think the question, I think maybe that's what you mean to say. And the Fifth Circuit, two judges agreed with you that it couldn't be upheld. So basically they said that if the tax penalty is gone, it's unconstitutional. But there was a dissenting judge who said it could still be upheld. And essentially the argument was that, that there's still, even though there's no penalty for it, there's still a basis for it. Well, one way to uphold it would merely be the judge also said there was no standing. So how can the people who are complaining have standing to complain if they don't really have to abide by it, right? The individuals, if they're not going to be paying a penalty. Two judges said they did have standing and one judge said they didn't. On the other question, the judge said that there was still a constitutional basis for it, even though the tax penalty had been taken away. But now I am blanking on the rationale for that. So I'm going to open it up.
I can jump in with a simpler answer. I mean, I think there's just a simple, straightforward argument that there are lots of taxes on the books that get zeroed out. that happens. It's not unusual. And so to the extent that the pretense for upholding the mandate originally was that the personal responsibility payment was a tax and not a penalty, you can still call it a tax, even though it's a tax of 0 right now, right? It's still on the books. They could add back to it, and then it would be a positive value tax. But that's just kind of the straightforward answer to it.
Oh,
I-
yes.
I think
And they added that maybe they could just impose a penalty of $1.
Well, there's a constitutional, right, that's the answer. There's a constitutional argument that the power to tax requires that it be a tax, and that a tax must be for the purpose of raising revenue. There's some suggestion in constitutional cases that says that. And so if it's not raising any revenue, it's not really a tax, and so the justification for upholding it disappears. And the easy solution is to pass a tax of $1. So this is a tempest in a teapot, some people have said, because no matter what the court rules, if Congress were to just change that, and presumably there might be a majority to change that if the threat was you're going to lose coverage of pre-existing conditions and young adults, up to the age of whatever, and 23 million people who can't afford it except through the, there is some argument that this whole case is being made to be a bigger deal than it actually is. We'll see. Questions? Any further questions? We're coming up on, so I see Harry's got a question. Harry LeBar, Harry, is your camera able to be activated? Are you?
Yeah, I can turn my camera on.
We'd like to see you. Harry's the second year who's in my Con Law 2 class, I think.
So my question is, if we get to mid-January and the votes still have not been counted and Trump is digging his heels in, which we know after last night that he would, how do you think the Supreme Court might respond to that?
So Bush versus Gore says there's a statutory deadline by which this has to happen of whatever, December 12th. And that if it doesn't, it then goes to the House. So that's an interesting question all by itself. If for whatever reason they don't meet their statutory deadline, that was an issue in the Bush versus Gore, but the Supreme Court stopped it before the deadline. But if they got to that deadline, so that in some sense they lost control and it went to the House, I think some people think it becomes the decision of the House and not of courts, that it would not be a court case at that point. But I think everything's up for grabs.
Rory, just one thing. I don't think it goes to the House if the deadline for it's called the safe harbor on the electors. If the state certifies its electors by its December 12th or 14th, I forget what it is, they're kind of incontestable. It's more open season after that. But the counting of the electors doesn't happen until January. It's the new Congress now that will count them, I believe, and the Senate that will count them. And the one thing I think you can take away from this is his term expires on January 20th at noon, and that's just true however you look at it. I can't see the court saying that somehow that doesn't happen, because the Constitution is just really clear about that. He's not the president of the United States unless he won the election.
Of course, none of us thought Bush versus Gore could happen either.
No.
I didn't. That's a good question, Harry. I see two cases about McGirt. Questions. Let's just see if I can read them here. Will it lead to other questions across the country? Absolutely, absolutely. Although the law here on Indian law and whether treaties are still in force or abrogated or how are they abrogated is remarkably complex. And Justice Gorsuch weaves his way through 100 years of precedent, basically. But absolutely, my understanding is there are now other suits have been filed based on old treaties. And does it set a precedent? This second question by Jillian Tang, Congress does have the power to disestablish reservations. They just were found not to have exercised that power, even though they admitted Oklahoma as a state. They never formally disestablished. So if Congress has the votes, they can do it. I think the concern for Native American civil rights is so much stronger today than it was at the end of the 19th century. I mean, the statements about Indians and territories that are surrounding the Oklahoma becoming a state are unbelievably racist and dismissive, if you will. And today we're in a different political situation. But I'm not we do have an expert on Indian law or Native American law at Hastings, Joe Carrillo, Professor Carrillo. And I do think that she'd probably have much more to say about this and probably would correct me on all the mistakes I've probably made. So please feel free to email Professor Carrillo. Other questions? I think we're going to call it quits because it is now 5 o'clock, a little bit after. Let me just say to those of you who stayed and attended, thank you so much for attending. Please follow up with questions to any of us if you would like to. And I want to thank my co-professors, my colleagues who I don't get to see in person and I really miss. Thank you for being part of this show, and see you on Monday.